Good evening, this is Rahul Reddy live from Houston, Texas. Reddy Neumann PC does bring in immigration news every week, Tuesday at 5 p.m. Central Time. Along with me is my business partner, Rebecca Chen. Rebecca, the premium processing has been returned right now. Does it mean that anybody whose application is pending, they can convert into premium processing right now, or is there any limitation on it right now?
Yeah, so USCIS is resuming premium processing in a phased way, so it's not open for everyone right away. The schedule that USCIS has put out for the way that they're going to resume premium processing is starting June 1st, starting yesterday. All I-140 applications that were pending or any new I-140 petitions that will be filed can be filed in premium processing. So for I-140s, premium processing is available pretty much across the board for the ones that were available before. For certain categories of I-140 that were not available before, they're still not available. Starting next Monday, June 8th, USCIS will start accepting premium upgrades for I-129 petitions for H-1Bs that are not filed in the CAP. So any H-1B extensions, transfers, amendments, other non-CAP subject H-1Bs that have been pending already, so ones that were filed before June 8th, those can be upgraded to premium processing starting June 8th, starting next week, and any other types of applications that are filed using the I-129 form that were also pending before June 8th can be upgraded starting next week. After that, June 15th, the next week, USCIS will start accepting concurrently filed premium processing applications for CAP-exempt petitions, but it's a pretty small number. So they've specified that it's only for employers who are CAP exempt. So those are mostly employers such as universities or higher education institutions that could file year-round outside of the CAP anyway, and petitions that are eligible for the Conrad waiver. So June 15th is going to be a pretty small number of petitions that can start filing in premium processing. The big date to be aware of is June 22nd. That following week is when premium processing will pretty much resume for all application types that were eligible for it before. They can be filed concurrently. Previous ones can be upgraded. So June 22nd is when it's expected that premium processing will basically return to normal. They have given the caveat that they might revise that schedule depending on how many applications and upgrade requests they get in the coming weeks, but that is the expected schedule.
Rebecca, is it only available for the people whom we are going to file, or what if my application is already pending? Can I convert it on the date? Like if my I-140 is pending there, I did not file in premium processing, can I convert it?
Yeah, so pending applications, if it hasn't been decided yet, it can always be upgraded to premium processing according to that phase-in schedule that we just mentioned. Basically, you just send in the additional $1,440 DHS fee along with the I-907 form and a copy of the receipt notice for the pending application. And once USCIS receives that additional fee and the premium request, they convert it from regular processing to premium processing, which means starting from that day that they receive it, they'll start running the 15-day processing clock.
Rebecca, we were expecting executive order. Now the second executive order comes especially on the point of the immigration. What do you see? I mean, do you see that is it only restricting all Chinese students or only certain Chinese students? What is the restriction that this executive order? Definitely it's only pointed out to the Chinese students, not to any other students, seems to be. What is there in the executive order? What are the restrictions that are there?
Yeah, this most recent executive order is also pretty limited in who it applies to. It applies to Chinese nationals from mainland China who are applying for F or J visas. Those are student or exchange visitor visas. At the consulates who are pursuing graduate studies, so it doesn't apply to anyone attending an undergraduate program, so it applies to graduate studies, master's programs, or higher, where the applicant has in some way been connected to the People's Republic of China's military-civil fusion strategy is the term. So either they were affiliated with an entity related to that, or employed by them, or have studied with them, or have worked with them in the past. So the executive order basically prohibits applicants for the F&J visa in graduate studies who have those associations in the past. It doesn't affect really that much people in the U.S. already in those visa statuses, even if theoretically they do have some connection to the military-civil fusion strategy. Technically, if they are in the U.S. already here, even if the State Department revokes their visa afterwards, as long as they remain in the U.S., they can continue staying here as long as they do not travel outside the U.S. So it is pretty limited, actually, in the scope of that executive order.
Do you think it might be applicable to Indians in any way?
We're not anticipating that right now. I mean, it seems pretty clear that the main kind of point of the executive order is, the president's unhappiness with China for a variety of reasons. We're not anticipating right now anything similar for Indian nationals, but yeah.
And what about the USCIS opening the offices right now? Is it like completely, did they closed off completely before, or they're opening it, or can you explain what's going on at the USCIS?
Yeah, so in March, along with a lot of other public offices, USCIS field offices, asylum offices, and ASCs, appointment support centers, closed to the public for the most part because of COVID-19 concerns. USCIS has announced that they are expecting to reopen June 4th, so this week. They're getting ready to reopen to the public with guidelines, of course, to try to safeguard people's health as much as possible. Their main priority is going to be rescheduling the appointments that were canceled in March and April, to reschedule those first. So if you did have a canceled appointment, your appointment was originally scheduled at an ASC or at a field office in March or April or May, right now, you're supposed to just wait until you get a new appointment notice that tells you when your new appointment time and date is, and that notice is supposed to also include a description of the new safety or health guidelines at that local USCIS office. So some of those include, obviously, if you have any symptoms related to COVID, if you're sick, they're asking you not to go, to contact them to reschedule. You can't enter the office more than 15 minutes before your scheduled appointment time, and the number of people that accompany you is limited. So just review that notice pretty carefully for those new guidelines when you receive it.
Rebecca, with regards to the DACA, which approximately around 700,000 people, employment authorization is there. Now, the Obama administration did bring in the DACA. That means this is, we call as dreamers, where if the people have come in under the 15 years of age into the United States and have completed the high school here in the United States, the Obama administration has given them the employment authorization. But Trump administration tried to take it off, but it's been fought in the courts. Now it's in the Supreme Court. What is expected? What's going on that?
Yeah, so obviously since the first year of the administration, even before that, the president made clear that he intended to eliminate the DACA work authorization and protections for this group of young people. So the administration has been trying to do that since their first year. The case has been, fought in lower courts. It's at the Supreme Court now, and it is expected that the Supreme Court will make its decision relatively soon, in the next month, but it could be any day now that we'll hear a decision on that.
Can you speak a little bit louder? What about the consulates, Rebecca? Are they open right now? Are they closed? What's going on with the consulates?
Yeah, so consulates worldwide are for the most part still closed for in-person visa appointments. We do hear of, some limited reopenings, or at least some consulates that are allowing people to start scheduling appointments for later in the summer. There are consulates in Mexico, for example, that are allowing people to start scheduling appointments later in the summer in July and August. It does seem to be kind of case by case, depending on the local consulate, the kind of local health situation there. But for the most part, in most U.S. consulates around the world, visa appointments are still suspended.
Any travel restrictions that are there right now? If somebody already have a visa and there are airlines that are servicing, especially from the Middle East, any travel restrictions that you see?
Not besides the ones that were already affected by the presidential proclamation in March, which are, for the most part, obviously China and certain European Schengen countries, those countries. So besides those, and obviously the executive order that was limiting immigrant visas at consulates abroad, we haven't seen any other travel restrictions right now.
Are there anything, if I were in Canada or Mexico, can I travel into the United States right now, or is there any restrictions on it?
Right, so the U.S.-Canada border and the U.S.-Mexico border are closed to non-essential travel right now until, I believe, June 21st for Canada and June 22nd for Mexico. So non-essential travel, it definitely includes travel for tourism, for just visitor purposes. That is not allowed right now until the end of June. For employment purposes, it does seem to be kind of more case by case. Definitely anyone who is traveling for health reasons, who works in the medical field, who works in the supply chain field, is considered an essential worker right now. They are being allowed to cross the border for those limited purposes. Besides that, other employment-based purposes, it does seem to be case by case and depending on the local port of entry and the consulates.
Let's go to questions, Rebecca. A question coming in is that from YouTube is, my I-140 has been applied, I haven't received a receipt notice. Can I apply the premium processing right now? No, you have to wait for the receipt notice for you to apply for the premium processing, because unless you have the receipt notice, there is no way that they can match the file. It's not that easy to match the bill of weight. You can also check if you can also check with your company or your lawyer to see if the check that was being sent along with the I-140 has been cashed. You can pull your file number on it. Based on that, you can file a premium processing. But in general, you have to wait until you get the receipt notice. How long does it take to get a receipt notice? It may take anywhere between at least 10 days to about 30 days. We are noticing, especially in Texas Service Center, it may take a longer time to get the receipt notice. Question from SSIR from YouTube. Is biometrics now available from F2 to F1? As Rebecca was pointing out, biometrics are available, but biometrics will be, if you have not taken the appointment, if your appointment has been cancelled, and they will reschedule you for the appointment for the biometrics. We are expecting biometrics to start from June 4th. They have not given any indication that the biometrics will not start. So from June 4th, the biometrics should start coming in.
We have a question from Facebook asking about their H-1B extension, which is pending for more than 240 days now, more than 240 days past their I-94 expiration date, and there's no update yet on the application. And they're asking, are they able to remain legally in the U.S. beyond that 240-day mark? So we have discussed that 240-day rule before in these sessions. So the 240-day rule refers to work authorization beyond the I-94 expiration date based on a pending, timely filed extension of status application. So what that means is after 240 days, technically, if you have not gotten an approval on that extension and if you have not filed another extension, you are not able to continue working beyond that 240-day mark. However, you are able to remain in the U.S. As long as that application remains pending, you're in a period of authorized stay and you can remain in the U.S., but you're not able to work until that application is approved. We would definitely recommend that starting next week, when you're able to upgrade your application to premium processing, that you do so that you can hopefully get your work authorization reinstated as soon as possible.
Questions from Gayatri is, questions, sorry, missed out. You good with any?
Okay.
One question is SSIR from YouTube is asking the question, the I-539, do we need to separate the checks for the biometrics and the 539? I strongly recommend you have two separate checks, one for biometrics, one for the regular things. Don't include both the things at the same time. Go ahead.
We have a question from Facebook asking about a TN transfer. It looks like the whole question didn't get posted, but most likely I think they were asking about transferring a TN from one employer to another. So if that was your question, then yes, you can transfer a TN from one employer to another by filing a change of employer on the I-129 petition with USCIS. The main difference, though, from for a TN transfer versus an H-1B transfer is there isn't the ability to start work for the new TN employer based on the receipt notice. So for H-1B transfers, as you know, once you file the new transfer application with Company B, for example, you can start working for them. You don't have to wait for the approval. There isn't that same option for TN transfers. You have to wait for the TN transfer application to be approved with the new company before you can move over and start working for them. So in those situations, premium processing is going to be much more important, and luckily later this month, premium processing is going to be reinstated. So we would definitely recommend that for a TN transfer.
Gayatri from Facebook has this question. Can she use the stimulus check? She's an H-1B visa. Absolutely you can. This is actually a tax that you already paid. They're giving it back to you. So you have all rights to take that money and use it. Absolutely no problem with it. Sachin Kumar has this question from Facebook. This question comes very frequently to us. He has a I-140 approved with a company and then he wants to go to a new company. Now here is the thing, Sachin, one thing that you left out, I'm covering out, I'm assuming it, that the I-140 has been approved for more than 180 days. If the I-140 has been approved for more than 80 days, if he moves to a different company, does the new company needs to file an I-140, or can he use the same I-140 with the old company to move to the company B and also from company B to company C? Here is the answer, Sachin. If the I-140 isn't been approved for more than 180 days, you don't have to file a new I-140 with company B or company C. You can use the same company A I-140 to move from company A to company B to company C, use the same company A's I-140, and from company C's to company D. Now you can use the same I-140 to get your wife a EAD approval based on company A, even though you are not working for company A. It doesn't matter if after 180 days, if the company withdraws the I-140, it will not affect whatsoever at all. It will still be yours for you.
A question from Facebook is asking about their H-1B extension, which has been pending since January 2020, and it sounds like the employer doesn't want to upgrade to premium yet and are asking kind of what the processing times are for an H-1B extension to be approved. Actually, in recent months, we have been seeing faster than normal processing times for extensions and other, actually all H-1B applications that have been filed in the last couple of months since they've all been in regular processing. We weren't expecting much at all as far as processing time, since we're used to regular processing taking, 6 or 8 months, sometimes more than a year. but actually in the past few months we've seen extensions approved within a month, 4 to 6 weeks sometimes. It may depend on the service center, so for an extension that's pending since January, it's possible that it could be approved any day now based on some of the processing timelines we've seen, but you also personally have the option of paying for the additional premium processing fee yourself. If the company is not wanting to upgrade to premium right now, you can discuss that option with them. The premium processing fee is pretty much the only portion of the fee, of the H-1B fee, that can be paid for personally by the employee, since it is optional.
Kavita from YouTube is asking this question. If the person is an Indian citizen and has a visiting visa, can they come into United States right now? If you have not traveled to Italy and China and some other countries that were listed in the executive order, at this point of time, there is no restriction for you to travel from India to United States. There are some restrictions from the Indian government, especially they're only having Air India right now fly from India. You have to make an application to the Indian embassy or Indian international authorities there to allow. But as far as the US is concerned, there is no restriction for you to travel into United States unless you have been in either Italy, I think so Spain is included in it, and China. If you've been there in the past 2 weeks, then you're not allowed to come in at this point of time. But otherwise, you can travel into the United States. Raj from YouTube has this question. What about travel to Mexico for visa stamping? At this point of time, this is our knowledge, please educate us. They do not have any appointments available immediately. They may, I think so, they do have appointments starting from August, but not before that. There's also the agreement between the Mexico, Canada, and US at this point of time, where they're only allowing the essential travel people. So we have had difficulties. In fact, I spoke with a gentleman today. He was stuck in Canada. He was trying to come back. They turned him around and told him, you're not important to come into the United States right now. So this is based on the agreement. It's not going to harm that person to come back ever again. But the issue is that if you go to Mexico, they may restrict you not to come back into the United States. The Mexico government may also restrict you not to travel into Mexico. Hopefully, we're expecting by the August time, all these restrictions will be gone. We do have a major problem that is coming up with regards to the student visa people. Most of the universities will start in August, and the appointments are not available in most of the consulates. What's going to happen? That's going to be a $1 million question. We are going to try to address it. What's going to happen with all the students?
We don't know right now. Yeah, we haven't really been in this situation before where the consulates were basically
you've been
shut down.
From the high school, you're working in immigration law office. You don't have experience?
No, not in this type of situation.
Yes, even I have more experience. I have almost equal experience as Rebecca. But yeah, even though my 23 or 24 years experiences doesn't look to be good at this point of time, we have no clue at this point of time how the student visa people are going to work out. We are expecting that the consulates will open pretty soon and the appointments will open, even though if you go to the US consulates in India, it says that it's almost, the availability is in February. We're expecting when the consulates are going to open, they're going to open quickly and they're going to process papers quickly. There will be openings before August. That's our expectation, because we're expecting, a lot of students, hundreds of thousands of students come every year on student visa, and that is going to restrict people if they don't get admission in the proper timing, if they don't get the visa. Now, even though the appointments are available in February, when they open it, they will open it for June or July. That is our expectation. We're going to contact the State Department to see if we can find any more information, how they intend to act on that. Now, also to note that when you're trying to make an appointment for B1, B2 visa, as compared to when you're trying to make an F1 visa, they normally normally give more importance to student visa people in a particular period of time, particularly in June, July, and August period of time. They do give importance to students. So they may say no to the B1, B2, but they may entertain F1 student visa people when they may entertain the F1 visa visa student people to come into. So we're hoping things will change, and you will be allowed, the student visa people will be allowed to get the opportunity to present themselves in the consulate.
Neha from Facebook is asking if a 501c12 nonprofit organization can file for a CAP-exempt H-1B. So this does seem to be sort of a misconception that we get a lot of questions on around this time of year when people were not selected in the lottery, unfortunately. It's not that any nonprofit is able to apply for a CAP-exempt H-1B. So it's limited to a certain category of organizations that many times are nonprofit, but just the fact that an organization is nonprofit doesn't make them eligible to file a CAP-exempt H-1B. So who can file a CAP-exempt H-1B? It is institutions of higher education, so universities and colleges, organizations that are affiliated with those higher education institutions. So the main example is like a hospital that is associated with a university to have medical students working there as part of their studies. So that hospital, for example, could qualify to apply for a CAP-exempt H-1B based on their affiliation with that college or university. And then organizations whose one of their primary functions is research, so research organizations that are nonprofits. For those types of organizations, USCIS does look at the operations of the organization to see if research is, just sort of incidental to that organization's operations, or if it is kind of one of their primary functions. So you'll probably have to consult with an attorney maybe to take a closer look at that organization to see if it qualifies for a CAP-exempt filing.
Manish has this question from YouTube. Do you expect some progress in the EB1 in this fiscal year? We are not expecting much progress. We are not expecting much progress in the EB1 in this fiscal year. We are expecting that the progress will be there starting from October of 2020. Jinai has this question: does premium processing lead to increase in the in the RFE? This question was asked many times before. No, Jinai, that is not true. Just because you apply in premium processing does not mean that you will get an RFE. There is no increased chance of getting an RFE. Jagan from YouTube has this question. PERM was filed in November 6th of 2019. Is there anything from the DOL? What are the things that are going in the DOL? If it's been filed in November 6, 2019, though, they should have adjudicated the labor certification. You can have your lawyer contact the Labor Department because it's definitely falling out of the time. What we're noticing is somewhere in the second week of December to second week of January is what we are noticing the labor certification approvals right now. We're not noticing anything that is in November that is pending. Srinivas from Facebook has this question: what are the projections do you for the EB2? Do you expect any priority date movement in the EB2? No, we're not expecting any priority date movement in EB2. We may be expecting some movement, not a significant movement in this year from EB1, and we may be expecting a good movement starting from October 1st of 2020 for the EB1, but we're not expecting much movement for the EB2. Just to reiterate, Srinivas, is that the priority date was May 1st, 2010 in March of 2012. So in the past 8 years, the priority date has moved back by almost 1 year. So to cross the May 1st of 2010, it may take a long time. That is our expectation. Now, hope I go wrong in this one.
Satish from Facebook is asking about his options, where it looks like he's just beyond his 60-day grace period after leaving or being terminated from a prior H-1B employment, and it looks like he has a transfer in the works to a different H-1B employer, but that LCA is not yet certified. So he's asking what his options are in that situation. It is difficult in that situation. There aren't any guarantees, but depending on how far it is beyond the 60-day grace period expiring. If it's just a few days, we would probably say it's worth it to still try filing the transfer and include the nunc-pro-tunc argument, which is where you ask USCIS to excuse the late filing and to ask in their discretion to still grant you the I-94 for extraordinary circumstances. So you would need to include some explanation or argument about those extraordinary circumstances in the application. So if it's not too much past the 60-day grace period, we would usually recommend that. I would definitely recommend filing it in premium processing since it's become available later this month, so that you can get an answer on that as soon as possible on whether you're going to get that I-94.
Divya from Facebook has this question. Her H-1B for the first H-1B that she got filed and got approved, it is revoked, and the employer is telling that he's not aware of receiving any notice and does not have any information about the revocation. The revocation happened with regards to the fraud and misrepresentation, and when she filed a subsequent transfer of the H-1B, she received a notice of intent to deny, and they are alleging that since you're not counted properly to the H-1B number, then you should not be getting this transfer application. Divya, I would recommend that you contact a lawyer immediately. There is a chance that your employer, the first employer, might not be giving full information to you. Also, if you apply for a H4 plus EAD, as what you have mentioned, it may not be good thing for you. You may have to leave the country though. The reason is that for your H4 to be approved, you must be in legal status in United States. Since your H1B with the first H1B has been revoked, you're not counted technically towards the H1B number. You are considered to be not in legal status in United States. That's why it's very important that you make a plans to leave the country. I would strongly recommend that you and your husband contact a lawyer as soon as possible so that you can determine, because lawyers can look into the information that they have in their different databases that they search, especially the people who practice immigration law. They can find out what exactly is going on with the company, how many H-1Bs they have filed, what is their end client location, did they use the in-house locations, is there any other things that may have going on with that particular company. Now, for example, the very busy law firms might get information about the company through different consultations. Hey, my H-1B is revoked for this purpose. They can give that information. So you may want to consult a lawyer. They may be aware of what's going on with the company though. We have noticed that especially the companies that have filed H-1Bs in in-house projects, these so-called in-house projects, they definitely get their H-1Bs revoked. And if they have used any of the end clients that are not proper end clients, that have used other consulting companies, even though that it's not an end client that they've used, got the H-1B, they get revoked too. So all those things need to be considered. So I would strongly recommend, since you may not be in legal status, you should contact a lawyer immediately.
Santos from Facebook is asking about his application that was filed at the Texas Service Center. He says it was more than 15 days ago and is asking about when premium processing will start. So just to clarify a bit on premium processing, when the clock starts and those timelines, if you had an application filed at a service center 2 weeks ago, it was definitely filed in regular processing because premium processing was not available yet at that time. It's only becoming available starting this month again. So your application was filed in regular processing, and in regular processing there isn't a certain clock where USCIS needs to take action on the case. Even though, like we've said, we've been seeing them process things faster, they're not under a deadline when it's filed in regular processing. When you upgrade a regular case to premium processing, from the day that USCIS issues the premium processing receipt notice, which is usually the same day they cash the premium processing check, the same day they cash that additional $1,440 DHS fee, the 15-day premium processing clock starts from there. So if you send in your upgrade request next week, for example, which is when most I-129 petitions that are pending can be upgraded, if you send in your additional fee and the I-907 request on June 10th, for example, you should expect to receive some action on the case by June 25th. That could be an RFE or hopefully a decision.
Amol has this question. What happens if during the perm advertising employer finds a U.S. candidate? Amol, it's not that the employer should just find a U.S. candidate. The U.S. candidate must also be willing to take the job. If the employer finds a U.S. candidate and that particular person is willing to join the company, if the company does not want to hire them, the perm process has to be abandoned. They cannot continue the perm process if there is. If the employer wants to hire that person and wants to still keep you, then the perm process can continue. Because if the employer has multiple openings and then he wants to hire more people, yes, he can take that candidate, he can still further pursue for the green card application.
Deepak from Facebook is asking about their H4 to H1B change of status. It sounds like they were selected in the lottery, which is good news, but their current H4 status expires on September 15th. I assume that the pending H4 extension that he's referring to is an application, an I-539 application requesting an extension of H4 status beyond September 15th. And if that is already filed and pending, then I would have your H1B petitioner file the I-129 petition as a change of status and attach a copy of your I-539 receipt notice, along with, of course, the approval notice that, or your I-94 that shows that your current H4 status is valid till September 15th. You need to get that H1B application filed by June 30th. Definitely don't wait beyond June 30th because you're waiting for your H4 extension to be approved first. You need to get that H1B filed by June 30th, or else you'll basically forfeit your lottery selection this year. So file it. If the H4 extension is still pending at that time, then just include the receipt notice, and on the form you can note that the H4 extension of status is still pending. The application can definitely be filed that way. It's just a matter of when the H1B will be processed. Basically, USCIS will wait for your H4 extension most likely to be approved first before they move on your H1B application. So it may take longer for your H1B application to be processed, but it should still definitely file it before the end of June.
Sophia has this question. What's going on the 40,000 green card for resilient program? This is what she's speaking about is for the nurses and the physicians. It's still that we are getting some more support of the senators at this point of time, but it's not tabled on the Senate, as the Senate is more working on the COVID response, PPP loans and other main issues that they are more concerned about. So it has not been tabled at this point of time. I would request all of you guys to contact the senators and the congressmen to put pressure on them so that that can be brought on the Senate floor and then passed in the Senate. But at this point of time, it's not put on the floor. It still is gaining the support, but still need to be put on the floor. Andy has this question. Does a 60-day grace period of the H-1B, can they include sick days and vacation date? Andy, there was a statement made by us before on this particular thing that got a little bit controversy, and then I've seen that floating around in the YouTube somewhere else, picking and choosing that particular thing. Now, here is the thing, Andy. It is on the day you got laid off. If you have some extra 6 days and extra vacation days, it is not, the 60 days starts from the time you got laid off, not if you have some extra vacation days, you're taking that extra vacation days. that does not start after the vacation day. It starts from the time you got laid off. Now, having said that, now there was a statement made by my partner in this YouTube before with regards to, yeah, in certain conditions, you can use those things. Now, here is the thing, Andy. It will depend on the officer, though. As a safety precaution, we like to restrict down straightly to the 60 days since the time you got laid off. Now, if you take the 6 days and vacation, it'll be risky. Have we done before? Have we been successful? Yes, we have been successful in saying that that should be counted, because after the vacation day should be counted 60 days. Have we failed in some of the arguments that we made? Yes, even that happened too, where the USCIS officer did not consider the vacation days as when the 60 days starts. So it's very risky to take that option, though. So if you have any other option that you can, I would strongly recommend that you stick with the 60 days from the time you got laid off. Kishore from YouTube has this question. His I-140 has been approved for more than 180 days, and it's not been withdrawn by January 17th of 2017. I added this sentence for you, Kishore. If the new employer files an I-140, if a new I-140 gets rejected, will it cause any problem for him for the further extensions? No, it will not cause any problem whatsoever at all for the further extension. If the first H-1B, first I-140 has been approved and it's been more than 180 days not been withdrawn, you should be very good.
So we had a question from, I believe, Divya. Sorry, can't find your name now, but I think she was asking about her H-1B being revoked due to fraud or misrepresentation. It sounded like that H-1B was the one that was...
I actually addressed that.
Okay.
Amit has this question. Taking unpaid leaves for less than 10 days, does it impact the H-1B status? This is coming from YouTube. Amit, if you are taking a leave because you want to take a leave, no, it does not impact the H-1B status. If the employer is forcing you to take it or implying that you take a leave, though, that may impact the H-1B status. But as far as if you voluntarily want to take it, you're sick, or maybe you want to take care of your kid, you want to just take a rest, tension's going on, you just want to sit home for 10 days, that's absolutely fine, no problem with it. Sadago Uday Bhaskar from Facebook has this question. His EB-1C council process is in progress. Is it advisable to enter into from L1 or H1, or is it going to be any risk? It's not going to be any risk whatsoever at all if you want to enter an L1 or H1 when your EB-1C council processing is going on. Absolutely no risk at all. Now, there are some visas, if you would like to enter while the EB-1C processing is going on, that will be risky. That is, if you're trying to enter on a B1 visa, if you're trying to enter on a student visa. But L1 visa or H1B visa are called dual intent visas. Even if you have an intention to permanently settle in the United States, it is not a hindrance that you can, it's not a hindrance for you to come on L1 and H1. These are the two strong visas. Of course, L2 and H4 are also available, but these are the two strong visas that you can come in while you are processing the EB-1C in the consular processing.
Stephen from Facebook is asking if it's possible to send in an additional client letter for an RFE response that was already sent in a couple of weeks ago. Basically, can he submit additional evidence after the RFE response was already submitted to USCIS? It really depends. There's no guarantee that USCIS will accept the additional evidence that you send in. I would say especially if it is past the RFE deadline, there probably isn't much hope of that additional letter getting added in or considered with the RFE response. If it's not past the deadline yet, and it was just a couple of weeks ago, you can try, I would say, go ahead and try to mail in the additional letter. reference the case number and make it clear from the letter, the cover letter, that it is, an additional letter to be added to an already filed RFE response. Like I said, there's no guarantee it'll get matched up with the file, especially if the officer has already reviewed it and made a decision. It may not be taken into consideration, but it's worth trying.
Rebecca, I need your attention on this case. Asim Khan is reporting from Facebook that so many of the students who are on STEM OPT are receiving emails that their visa got revoked. Are you listening to it?
I have not heard of
We
that
are not
recently.
aware of any of those things, Asim, that people are getting the revocation emails. We are not into. If you have anything, you can drop an email to Rebecca or me, and we want to see what's going on. I mean, I'll be very shocked. We haven't seen it at all. The past 10 days, we have not seen it. There are some universities that got into trouble, but in the past, we have not seen anything recently on that. So if there is anything, please forward it. And if you want to, please, Asim, you can make a note on which university is this that you're speaking about that got the revocation. We want to look into more. And if you send an email, we'll try to address this in the next week, though.
So someone on Facebook is asking if it sounds like if someone in H-1B status can apply for a driver's license in a different state. As far as I'm aware, there isn't any restrictions just based on the fact that you are in H-1B status. There may be restrictions in that state just due to their driver's license rules. They may require you to be a resident of that state, most likely, but just based on being an H-1B visa holder shouldn't make too much difference. So I think it'll depend more on the DMV.
Nadan Shah has this question. My employer is, from Facebook, my employer is not giving any information on the PPP loan. He's not sharing any information. What are my rights? Nadan, that is a loan to the employer. Under certain conditions, it can be waived. So you don't have any rights to get the information, what the loan information is. It's a very personal information of the company that is getting a loan from a bank. So you do not have much rights on getting any information on that. But if he misinforms, saying that he did not pay you the salary, and he informs that he paid the salary, that is a crime upon him. But there is nothing, you have any right on it to ask for any information. But if he has if he has put you on the payroll and he's paying you salary, that's fine. But he has not put you on the payroll and he's saying that he paid you the salary to the government, that is fraud. That's the only thing that you have a right, but otherwise you can't ask any information.
Vinod was laid off, unfortunately, from his position when he was in H-1B status, and it looks like he applied for a change of status to B2. He says to avoid unlawful presence in the U.S., but he said that his I-94 is valid until 2022. So actually, unlawful presence starts to accrue after your I-94 expires. If you filed for a change of status to B2, my assumption is that it was because you were not able to get another H-1B transfer filed within the 60-day grace period. And
but technical words keeping aside, Rebecca, he will be out of status in stuff.
Right.
In stuff. So he may have used
rather than unlawfully present.
Now these are technical words. So he's trying to prevent himself to go to use the B2 application to prevent himself to be not
out
be in the out of status.
Yeah.
Yeah, that's a good option for the people who lose a job to maintain the status. You should move to B2, but don't expect to come back to the H-1B. If you get an offer, they have to do the consular processing. That's the only way for you to come back, and you have to go outside the country and probably get the stamping outside the country and come back. That's the only way. Yeah, they use wordings of unlawful and out of status very frequently. It's a very technical word, so I just want to make sure that it's not unlawful, it's out of status. We also use a lot of times words. So if you have an I-94 and if you're not maintaining the status, it is considered to be out of status. And to prevent that, you should file a B2 application. You can leave the country, but unfortunately at this point of time, a lot of flights are not there to leave. You can't swim from USA to your home country. So yes, you should apply for a B2 application.
Yeah, on this.
Manu from Facebook has this question. Premium processing, starts from extension as well? Yes, starting from June 8th, extension is available. Rebecca, I interrupted you. You were speaking.
I was just saying on the subject of the B2, I saw a couple of questions that were sort of along those lines. Someone who it looks like was trying to apply for a B2 because they are unable to get a flight out of the country before their I-94 expires, but their I-94 isn't showing up on the CBP website. So we have heard of that happening. For some reason, it does happen pretty frequently for people who enter on a visitor visa, that their I-94 record doesn't show on the CBP website. In that case, you can try calling the Deferred Inspection Office or the local CBP Deferred Inspection Office for that city. Each one has a slightly different procedure, so make sure you look up online how that CBP office deals with deferred inspections. If it allows you to make a call or even send an email, that's usually preferable rather than going in person.
Also, the CBP office, when your I-94 is not appearing on there, I have noticed, Rebecca, that when you call the USCIS, they're able to get the information. When you call the CBP, they're unable to get the information. I don't know how that is working out. So you may want to also try to call the USCIS office to see if they have the information. That may work out very good for you. Never go to CBP office without checking with a lawyer. We have had some people who go to CBP office saying that, hey, my I-94 is not appearing. And they said, well, you are illegally present here. And they detained him, and it took a while for us to get that guy outside the custody. So don't go to CBP office without consulting a lawyer, though. What I would recommend is that if you don't get the CBP person on the phone, try to do the same thing on the USCIS. Call them up. You might be able to get it. If not, contact a lawyer. That's a better way. Don't go to CBP office. We've seen recently many of them are getting detained.
Prathamesh from Facebook is asking about his H4 and H4 EAD, which are pending, and it sounds like he's about to apply for an H1B also, possibly, and asking which one would be effective, basically. So it'll depend on which gets approved most recently. So you can always withdraw one of them. If one of them gets approved and you decide to use that, for example, if your H1B gets approved and you decide to use your H1B, I would recommend withdrawing the H4 and EAD so that because you don't need it anymore. And if the H4 and EAD get approved as a change of status after your H1B is approved, you're going to be in H4 status, basically. It's called the last action rule. Your most recent I-94, which is issued to you from USCIS, or when you enter the country, is the I-94 that controls your status. So if you want to use one over the other, then see which one gets approved first and maybe withdraw one, or wait for the other one to get approved, and then that should be effective.
Gopi from YouTube has this question: is the employer obligated to withdraw the I-140 approval? Or is it a choice of the employer? Most of the time, it is the choice of the employer to withdraw the I-140. But sometimes, when there is an RFE on multiple I-140s, sometimes the USCIS will send an RFE, show the ability to pay for each and every employee. At that point of time, if there is any I-140, and if the person is not working, they may be forced to withdraw the I-140. So sometimes they are forced. Gopi, as such, if the I-140 has been approved for more than 180 days, it may be better for them to withdraw, though, because it may be better if you're an employee, because you don't want that I-140 to be revoked for ability to pay also. If that happens, you're gone, and you don't want that. So for all reasons, it is in the best interest of the employees also to have the I-140 withdrawn, especially after the 180 days. It is also in the best interest of the employer to withdraw, because of this particular person, the entire company's I-140s might be revoked. So that's a precautionary method. A lot of employers take it by withdrawing it. We normally tell employers and employees, have it been there for 180 days, then they should withdraw if the person leaves the company.
Manu has a question about whether maternity leave terminates H-1B status, and if not, how many days are permissible in H-1B status for maternity leave. So it does not terminate H-1B status as long as it is being requested by you as the employee to go on maternity leave, and as long as it's not being an unpaid leave that's being imposed on you by the employer. So something that's imposed by the employer where you're basically being benched and not paid, that is not allowed. But if you are requesting maternity leave yourself, then that is fine. It doesn't terminate your H-1B status. You can maintain your H-1B status. I would definitely make sure you and your company keep records of the leave, including your request. Even if you made the request verbally to your manager, send an email so that it's in writing, the date that you requested, how much time you're requesting, and the approval from HR of your company. Sometimes we include that letter actually in place of most recent pay stubs if you're having to file an extension or something. That is also proof of your valid maintenance of H-1B status if you requested maternity leave properly and it's documented. As for how much time you can take, it depends on, I would say it would just need to be in line with what that company's normal policies are for its other non-H-1B employees. So if that company is subject to the FMLA, they have to abide by that, obviously. And any additional leave beyond that that you want to take, that you are requesting, like I said, even if it is unpaid, if the company allows that for its other non-H-1B employees, then it should be permissible. But again, just make sure you have documentation of those policies and the requests and approvals of the leave.
Aarti from Facebook has this question. She has a master's degree. Can she go for AB3 rather than AB2? Yes, you can. It's not what you have, it's what the company requires for the position. That will control. You may have a doctorate degree, you may have an Oscar award, you may have a Nobel Prize, but if the position only requires bachelor's degree, then you have to go for AB3. Alan from YouTube has this question. Can somebody, an H4 EAD, start a business, S corporation or LLC? Alan, yes. They can start either S corporation or LLC. Absolutely no restriction, none whatsoever at all. There are some CPAs that will come back and tell you that, look, only residents of United States can be partners in S corporation and LLC. And they will try to tell you that, look, the residents according to the immigration definition includes only green card holders, not H4s. Our answer to them is that no, H4 EADs are residents. 99% of the time they're residents maker. Some exceptions available. They should look into the definition of the IRS to find out what is a resident, not look into the INA, which is Immigration and Nationality Act. They should look into the IRA regulations, and the IRA clearly defines that H4 EADs are residents of United States. So you can open S corporation or LLC. It's up to you.
Debbie from Facebook is asking about SOC code 15-1121. He's heard rumors about that SOC code, but his I-140 was filed using that SOC code, so he's asking if it's going to have any impact on his green card process. So the issue around that SOC code 15-1121, which applies to computer systems analysts, it's primarily in the context of H-1B applications. So this was a pretty common SOC code used for H-1B applications for many years until 2017, basically the summer of 2017, when it became clear from requests for evidence that USCIS basically no longer considers computer systems analysts or other positions under that SOC code as qualifying for an H-1B visa. They basically take the position, for the most part now, that 15-1121 occupations don't require a bachelor's degree to perform the duties and therefore do not qualify for an H-1B visa. There are some exceptions, and we have been able to get some approvals in some exceptions where the actual position itself can be proven to be very specialized. But that is sort of the buzz around that particular SOC code. I would say it's not going to have that much effect on your I-140 petition, because for the I-140 petition, it's not required, it's a different standard. You're not required to be sponsored for a specialty occupation at the I-140 stage. Many times you are, because a lot of times there's overlap between your H-1B position and your I-140 position, but it's not required. You're not even technically required to have a bachelor's degree or for the position to require a bachelor's degree at the I-140 stage. For EB3, technically the position only at the minimum requires 2 years of work experience. So as long as that position is still available for you technically with that company that sponsored the I-140, it should not have an effect on your green card process.
Before we go, Amrut Reddy has this question: have you seen any H-1B approvals for the 2021, the ones which we filed from April? Yes, we have seen some approvals for the H-1Bs that have been filed. Yeah, please note that these are not filed in premium processing. The premium processing did not exist until and does not exist until June 22nd for the quota. But yes, we have seen some H-1B approvals for the things that have been filed in the quota. Anything else, Rebecca, before we close?
No, I don't think so.
Thank you, Rebecca. Thank you, everybody, for tuning in. Don't forget that we do have a daily conference call and the details of them are at rnlawgroup.com. Don't forget to subscribe to our news section at RN Law Group. You can get all the news that goes on. And our business partner, Emily Neumann, also has a blog called Immigration Girl. She puts on all the news as soon as the things come out. And thank you guys for coming. Thank you, Rebecca.
Thank you.
Thank you.